This interview is a reconstruction for educational purposes. Some content, including narration, visuals, or examples, was generated with AI to illustrate legal concepts. This is not legal advice and does not reflect any real individual's experience. For questions about your own situation, please consult a qualified attorney.
Like and subscribe. Your support helps us create more educational content for you.
Welcome back to Legal Matters. I'm your host, Sarah, and today we're tackling a California legal concept called intentional infliction of emotional distress. It sounds technical, but we'll make it easy to understand. Joining me is Professor James Whitfield, a professor of law here in California. Welcome, Professor.
Thanks, Sarah. Glad to be here.
Let's start with the basics. What is intentional infliction of emotional distress?
In California, it's a type of claim someone can bring if another person's behavior is so extreme and outrageous that it causes severe emotional suffering. But the law sets a high standard, and not every hurt feeling qualifies.
So what exactly does someone have to prove?
There are 4 essential elements. First, the defendant's conduct must have been outrageous. That means behavior so extreme that it goes beyond what's normally tolerated in a civilized community. Second, the defendant must have either intended to cause emotional distress or acted with reckless disregard, meaning they knew their conduct was likely to cause emotional distress, and the plaintiff was there when it happened. Third, the plaintiff must have actually suffered severe emotional distress, not just mouth upset, but something serious that a reasonable person couldn't be expected to endure. And fourth, the defendant's outrageous conduct must have been a substantial factor in causing that severe emotional distress.
That's very clear. So it's not enough to just show that someone was mean or insulting.
Exactly. California courts have said that insults, annoyances, or even threats usually aren't enough by themselves. The law is designed for situations that are extreme, behavior that crosses a serious line.
And who decides whether the conduct is outrageous?
The judge first decides if the conduct could reasonably be considered outrageous. If so, then it's up to the jury to decide whether, based on the evidence, it truly was outrageous and whether it caused severe distress.
So to sum it up, in California, to prove intentional infliction of emotional distress, you need outrageous conduct, intent or reckless disregard, severe emotional distress, and proof that the conduct caused that distress.
That's exactly right.
Professor Whitfield, thank you so much for helping us break this down in everyday language.
My pleasure, Sarah.
And to our listeners, remember, this discussion is just for education. If you have questions about your own situation, it's important to consult a qualified attorney. Stay tuned for more on Legal Matters.
Question: which of the following best describes the severe emotional distress required in intentional infliction of emotional distress claim? A. Mild annoyance or temporary frustration. B. Emotional upset that a reasonable person could endure. C. Emotional distress so serious that a reasonable person could not be expected to endure it. D. Feeling slightly embarrassed or insulted. Answer: C. Emotional distress so serious that a reasonable person could not be expected to endure it.